In this video, we're going to talk about how to protect your assets from your daughter-in-law or son-in-law. A common concern I get from clients is they want to keep the wealth in their family, and their child has married someone that causes them concerns. Or maybe they get along with their child's spouse but worry about a divorce or lawsuit. I'm going to share some common examples and then I'll share some strategies. For example, I had a client whose daughter was super financially responsible, but she married a man who had a gambling issue. And the clients wanted to be sure if their daughter died, that their money would go to their grandkids in a protected way and not be lost to gambling. Another common fear that clients share with me is fear of divorce. They like their son-in-law or daughter-in-law, but with the high divorce rate, they want to be sure their estate will go to their kids and grandkids and not get lost in a messy divorce. Another example is a daughter-in-law has her own kids, and the parents want to make sure the inheritance is going to go to all the grandkids, not just the daughter-in-law's kids if the son were to die first. Or maybe the daughter-in-law is in a high-risk profession and they are worried about lawsuits. And finally, I do get a lot of people who come to me with concerns about their daughter-in-law or son-in-law's spending habits and how they blow through money quickly. So let's go through 3 options. One option is to simply leave the inheritance to your child outright. Some parents research this and see this inheritance as separate property. However, inheritances that children receive are often intentionally or unintentionally commingled with community property, causing the inheritance to lose the separate property status. For example, intentionally commingling might be you leave $100,000 to your son and his wife says, put it in our joint bank account. And your son does, and now it's joint property. Unintentional commingling would occur because the money is invested in something and that appreciation during the marriage becomes community property. Often leaving to your child outright is not the best option because there's too much risk and not a lot of protection. A second option parents have is to leave the child's inheritance to the child in a trust for the benefit of the child or the grandchildren. Utilizing a trust does provide some protection. If the parent names the child as the trustee, the child's spouse could exert influence over the child and force the child to give distributions that commingles the assets. Some parents tell me, let's just do this, and it's up to the child to protect it. The child's spouse could exert an influence over the child and force the child to take excessive distributions from the trust. But some parents tell me, let's leave it in a trust for our child and name our child as the trustee. If our child messes it up, so be it. We did what we could to protect our child. And another option with this strategy is to have the spouse sign a document acknowledging that the inheritance is the separate property. And in many states, that could provide some additional protection. A third option, and the strongest option, is to leave your child's inheritance to them in a trust, but name a third party as the trustee of the trust. In essence, restricting your child's access to the funds. By restricting that access of the trust, you are restricting your child's spouse from influencing your child's access to the trust. This third party could be a private institution, another family member, or a trusted friend. You may even wish to name your grandchildren as the beneficiary of that trust, so that when your child passes away, the remaining trust assets would stay within the bloodline, benefiting your grandchildren. I know these decisions can feel uncomfortable, and often people put it off. You do not want to do that, because when you put it off, it's often too late. There are many factors that play into how you leave an inheritance to your children. You must factor in the community property laws of your state, the trust code, laws of which trust property is separate, and community, family law, marriage contract laws, and laws allowing spouses to sign agreements reserving specific assets. It is important to work with an attorney in your state to put together a plan aligned with your values and which follows your state's laws. If this video was helpful, your next step is to watch my video on the 5 living trust mistakes linked here. In this video, I share common trust mistakes and how to avoid them.